You might think something like this is impossible. You might assume it could never happen in modern American politics. But what I'm about to explain is unfolding right now, and it represents one of the most consequential judicial moments in modern U.S. history. A federal judge has revoked Donald Trump's bail and ordered him into custody pending trial. This is not a minor procedural setback. This is not a brief detention pending review. This is a federal court determining that a former president of the United States poses a danger to the integrity of the judicial process and must be held in pretrial detention. When a federal judge reaches that conclusion about a former president and current presidential candidate, the implications are enormous. What triggered the bail revocation? Federal prosecutors filed an emergency motion arguing that Trump systematically violated the conditions of his release. According to their filing, he repeatedly targeted witnesses, prosecutors, and court personnel through social media posts and public statements. The motion documented over 40 posts that prosecutors characterized as threatening or intimidating. These messages allegedly included identifiable references to witnesses expected to testify against him, language suggesting they would face consequences, and statements interpreted as encouraging supporters to take action. This wasn't based on one isolated comment. Prosecutors presented what they described as a pattern, a deliberate and escalating series of communications. Judge Tanya Chutkan reviewed the evidence and held an emergency hearing in Washington, D.C. After hours of arguments and testimony, she concluded that Trump's conduct created a present and serious risk to witness safety and the fairness of the proceedings. Her decision revoked bail. The emergency bail revocation hearings are rare in federal court. For a former president, they are unprecedented. During the hearing, prosecutors walked through a timeline of Trump's posts and public remarks. They argued that within hours of certain court filings identifying cooperating witnesses, Trump would publish statements referencing them in ways that made their identities obvious. Prosecutors presented testimony from witnesses who described receiving threats after being referenced in Trump's posts. One former White House aide testified that she received hundreds of threatening messages within 24 hours of being publicly mentioned. Another state election official described supporters appearing outside his home after Trump criticized corrupt officials in connection with the case. The prosecution's argument was straightforward. This was not abstract political speech. It was conduct that resulted in real-world intimidation. The defense argument, Trump's legal team countered that his statements were protected political speech under the First Amendment. They argued that as a presidential candidate, he has the right to criticize prosecutors and defend himself publicly against what he describes as politically motivated charges. They maintained that his comments fell within the realm of permissible political advocacy. Judge Chutkan focused on one key issue: whether the defendant understood that his release was conditioned on not intimidating witnesses. She emphasized that subjective belief about political speech does not override court-imposed restrictions designed to protect the judicial process. Her ruling made clear that constitutional protections do not extend to speech that demonstrably leads to threats and witness intimidation. The legal standard under federal law, bail serves two core purposes: ensuring the defendant appears at trial, protecting the community and the integrity of judicial proceedings. When a defendant violates release conditions, particularly by attempting to intimidate witnesses, judges have broad authority to revoke bail. This is not new in principle. In 2018, Paul Manafort, Trump's former campaign chairman, had his bail revoked after a court found he attempted to tamper with witnesses. He remained in detention pending trial. In 2023, former FTX executive Sam Bankman-Fried had his bail revoked after prosecutors demonstrated attempts to influence witnesses. He too was detained through trial. Federal judges routinely detain defendants who show they cannot comply with court orders. The unprecedented factor here is not the legal reasoning. It is the identity of the defendant. The court's written order, in her written ruling, Judge Chutkan concluded that Trump engaged in a deliberate and systematic effort to identify and target witnesses through public messaging. She noted that he had previously been warned. Modified conditions had been imposed. Yet the conduct continued. The court determined that no alternative set of release conditions would sufficiently mitigate the risk. The order directed U.S. Marshals to take Trump into custody and transfer him to a federal facility where he would remain pending trial. According to reports, he would be housed in a secure unit appropriate to his status as a former president, separate from the general population. The ruling explicitly rejected arguments that his political prominence warranted special treatment. The principle articulated was simple: the rule of law applies equally. Immediate political impact: the political consequences are extraordinary. A major party presidential candidate now faces the possibility of conducting a campaign from federal detention. Public rallies become impossible. In-person debate participation becomes uncertain. Campaign messaging must shift toward surrogates and legal statements. Fundraising efforts may continue, but the optics of detention introduce unpredictable effects on public opinion. Supporters may view the detention as persecution. Critics may see it as accountability. Polling reactions could swing either direction. But operationally, the campaign faces severe disruption. The appeal process: Trump's legal team is expected to appeal the detention order to the U.S. Court of Appeals for the D.C. Circuit. However, appellate courts review bail revocation decisions under an abuse of discretion standard. That means they defer heavily to the trial judge's factual findings unless they are clearly erroneous. If the record supports findings of witness intimidation, reversal is statistically uncommon. Legal scholars have noted that while the political context is extraordinary, the underlying legal framework is well established. Broader constitutional questions: this development raises unprecedented constitutional and democratic questions. The U.S. Constitution does not prohibit a detained individual from running for president. There is no explicit clause barring a candidate under indictment, or even in custody, from campaigning. This creates an extraordinary theoretical scenario: a presidential candidate running while detained on federal charges. Scholars are now debating how detention interacts with campaign communication rights, debate access, media fairness, and Secret Service logistics. Yet at the core of the issue lies a simpler question: can the judicial system protect witnesses when the defendant commands a massive public platform? If courts cannot enforce release conditions against powerful defendants, the integrity of criminal trials collapses. Witnesses must be able